General overview of the application process. The online VFA agent application needs to be completed by persons wishing to be registered as VFA agents under Article 7 and/or Article 14 of the Act. The applicant should make reference to Title 2 of Chapter 1 of the VFA Rulebook, the corresponding glossary of terms, and the guidance note to the VFA agent application for the entire registration process. These may be accessed in the dedicated section on the MFSA website relating to the Virtual Financial Asset Framework. The application consists of 4 parts, each of which needs to be completed in full. Part 1 covers the general details of the applicant. Part 2 covers operational capacity and requirements. Part 3 covers prudential requirements. And lastly, Part 4 covers application fees and a declaration form. Any scanned documents should be uploaded in PDF format unless otherwise specified and be of sufficient resolution to enable legibility. Uploaded documents should be saved as clearly explained in the guidance note, indicating the date, applicant name, and document name unless otherwise specified. Any documentation which is required to be signed and in original should be submitted by mail to the MFSA to the attention of the FinTech team. The application should be completed in a sequential manner, proceeding from Part 1 to the next. Upon saving and continuing towards the subsequent part of the application, the applicant would not be able to modify and/or alter that part in any way or form. Part 1. General details, incorporated, registered, or otherwise. Section A. VFA agent details. The applicant is requested to indicate through the type of registration whether the application is in relation to Article 7 or Article 14 or both. This is crucial as each respective article enables the VFA agent to operate either to represent issuers of virtual financial assets or VFA service providers. The applicant may still proceed with the application should the entity be still in formation. This may be done by inserting NA for the entity registration number and by leaving the registered date blank. In this case, the general details of the applicant should be understood as being proposed details. These would then need to be updated once the MFSA issues its in-principle approval, upon receipt of which the applicant shall proceed with the incorporation or registration of the entity. For entities that have been formed prior to the coming into force of the VFA Act or foreign entities, the applicant is required to upload the memorandum and articles of association or any other constitutional documents as evidence of the entity's setup, and a board resolution, or, in the case where the entity's legal form is not a company, a document indicating the administrator's agreement to apply for registration as VFA agent. Entities that are pending formation are to upload a draft memorandum and articles of association or any other draft constitutional documents, and a draft board resolution or a draft administrator's agreement to be signed and dated upon incorporation or registration. Section B. Organizational structure. The applicant is required to provide an organizational chart reflecting clearly both the existing or proposed unit holding structure and the group structure, depending on whether the entity has been formed or not. The unit holding structure should clearly depict its hierarchical setup, including the percentage unit holding of all the unit holders up to the ultimate beneficial owners. The group structure should indicate all the entity or entities in which the applicant has a holding and the respective unit holders of these companies. Here the applicant has unit holders whose transferable securities are listed on a regulated market and which are subject to public disclosure requirements. The applicant shall only be required to identify those unlisted units which are not subject to sufficient disclosure requirements. The applicant will also need to outline the unit holding structure within Annex 1 to the VFA agent application form. This form should be downloaded, duly filled, and uploaded to the application in .xlsm format. The Annex 1 shall indicate to the applicant which individuals require a PQ, which entities require an entity questionnaire, and whether further details should be specified under regulatory history. It is important to note that individuals that require a PQ should prepare and submit an unassigned PQ prior to the applicant submitting an application. The applicant is required to use the PQ reference number generated specifically for the individuals in the application. The applicant should also attach to the application entity questionnaires of those entities which have a qualifying holding in the applicant. This entity questionnaire should be completed in accordance with Title 4 of the Guidelines to the VFA agent application. This questionnaire should be uploaded in .xlsm format, while the declarations sheet should be signed by 2 representatives of the applicant in accordance with subsection 3, section 5 of Title 2 of these guidelines. Section C. Regulatory history. The applicant is required to disclose whether its beneficial owners or qualifying holders or any entity or entities in which the applicant has a qualifying holding ever sought any kind of authorization whatsoever by the MFSA or any other regulatory authority. Part 2. Operational capacity and requirements. Section A. Business plan. The applicant is required to outline its business plan within this section. This document, which has to be attached and uploaded with the application, shall contain the information on the applicant and, as a minimum, provide for an overview of the organization, an outline of the applicant's strategy and rationale behind the decision to become involved in the VFA agent business and commence operations in Malta, a detailed description on the internal controls of the applicant, namely on how the proposed operational setup and controls meet the governance requirements set out in Chapter 1 of the Virtual Financial Assets Rulebook. The due diligence systems, tools, processes, and controls the applicant will have in place in order to enable it to conduct fitness and properness assessments on clients, and the security mechanisms in place to guarantee the security and authentication of the means of transfer of information, minimize the risk of data corruption and unauthorized access, and to prevent information leakage, maintaining confidentiality of data at all times. And lastly, the business plan should also include the financials of the applicant by illustrating the budgeted financial forecast for the next 3 years. Section B. Internal governance. The applicant is required to outline in this section its internal governance structure, namely the directors, proposed appointed persons, and proposed designated persons. The applicant shall not be able to proceed with the application unless it proposes the respective internal governance arrangements in accordance with Chapter 1 of the VFA Rulebook, being 2 administrators effectively managing and directing the VFA agent's business, one of which should be executive, and at least 3 designated persons. The applicant should note that from the 3 designated persons, 2 shall be responsible for performing the activity of a VFA agent under the Act, and 1 shall also be appointed as the MLRO for the VFA agent. Please note that these individuals would require a PQ, which would need to be prepared and submitted prior to the applicant submitting an application. The applicant is required to use the PQ reference number generated specifically for the individuals in the application form. Section C. External outsourcing agreements. The applicant is to specify any outsourcing agreements of operational functions, and if due diligence is outsourced, the applicant is required to disclose the person to whom this function has been outsourced to. The respective outsourcing contract should also be uploaded to the application. Part 3. Prudential requirements. Section A. Capital and contributions. The applicant is required to specify the respective capital or contributions within the entity. Where the entity has not yet been formed, the applicant should specify the proposed capital or contribution which shall be injected into the entity for the purposes of the initial capital requirement. A distinction is made between capital and contributions. For entities that are established as a company, the applicant has to disclose the authorized share capital and issued share capital in the respective reporting currency. For entities that are not established as a company, the applicant is required to disclose the total contribution in the respective reporting currency. Additionally, the applicant is required to upload evidence of paid-up capital and other types of capital contribution raised. Where the entity has not yet been formed, the applicant is required to upload documentation evidencing that sufficient funds are in place to be injected upon issuance of the in-principle approval. Section B. Insurance. If the applicant has a professional indemnity insurance, this has to be disclosed, and a copy of the insurance policy is to be uploaded. Any other insurance policy that the applicant has entered into with third parties has to be disclosed, and a copy of the insurance policy is to be uploaded. Part 4. Application fees and declaration form. Section A. Payment of application fees. The authority shall not commence the review of an application which has pending fees. The applicable fees may be found on the Virtual Financial Assets Regulations. The following details are required to be submitted by the applicant. Payment method. Bank. Payment reference number. Payment date. Section B. Declaration form. The applicant will also need to download Annex 2 to the VFA agent application. Following the insertion of the required fields in the declaration sheet, this form should be duly filled and uploaded to the application upon being signed by 2 representatives of the applicant in accordance with subsection 3, section 5 of Title 2 of the guidelines. An original copy of this declaration sheet should also be submitted to the authority. Finally, the applicant is also required to agree with the declarations found at the end of the application prior to submitting the application form. Should any queries not be addressed or other problems are encountered, please contact the MFSA on email fintech@mfsa.com.mt.